Copyright is a so-called intellectual property, and it protects original fixed expressions of authorship. So, for example, novels, songs, paintings. It's generally called intellectual property, but I've actually advocated calling it intellectual privilege. And the difference between property and privilege is this. A property right is one that exists at common law and is protected with quite stringent legal remedies, whereas a privilege is something that's created solely by statute. It's invented by lawmakers. And usually the remedies for violating a privilege are less draconian than they are for violating a property right. And for copyright, I think that would be appropriate. One reform that I'd like to see implemented for copyright is to go back to the 1790 Copyright Act in the United States. In the United States, after they founded the United States government, they very quickly implemented a copyright law. This was in 1790, just 1 year after they ratified the Constitution. And so that tells us what the founders of the United States thought about copyright, because they wrote the first law. And if you look at their law, you'll see that it's very different from the law we have today. It's much leaner, it's more elegant. And so one reform I'd like to see implemented is for us to go back to those ideas. So for example, copyright would be much shorter under the 1790 Copyright Act, only 28 years maximum, whereas today copyright can last for the life of the author plus 70 years. That could easily be 100 years, easily 100 years. Another thing the founders did with copyright is they didn't afford for criminal penalties for violations of copyright. And also, the only copyright you had was to prevent someone from making an exact duplication of your work. Well, now copyright reaches much more broadly. It lasts a long time. It protects against even reinterpretations, such as a translation of a work. And the remedies are much more draconian. Now you can get thrown in jail for violating copyright. The founders only allowed monetary damages. Another reform that would be nice to see done with copyright is to simply stop calling it property. If people would rethink it, I think they'd realize it's more like a privilege. The analogy I like to use is property might apply to, say, real property, real estate, or tangible property like a computer or a purse. A privilege would be something like a taxi medallion or a license to operate a business. And I think copyright is much more like the latter. It's much more like a privilege. The government says, we're going to create this special limited right just for you because we want to have some nice policy result. It's not because we think there is a natural right for you to own this thing. No one has a natural right for a taxi medallion, say. But you can make an application to a government office and they'll give you the rights that they think you have to have. That's the way we ought to view copyright. So it's a conceptual change. We should stop thinking and talking about it as if it's property and start thinking and talking about it as if it's simply a privilege, which means it would be more limited. It's something that we wouldn't defend as a natural right. In the United States, copyright and constitutional law are in tension. I would say conflict, except U.S. courts think that they've worked out these tensions. I'm not convinced they have, but they're in tension. And why? Well, because the Constitution protects both property rights, intangibles, and it protects our right to freedom of expression. And copyright is in tension with both of those other constitutional rights. Now, I should say, because it's true, that the Constitution also provides for copyright. But these principles are in tension, so here's why. When someone owns a copyright, they can say to someone else, you can't use your printing press the way you want to use it. You can't use your guitar the way you want to use it. You can't even use your own throat the way you want to use it. You can't sing my song. You can't print on your printing press, you can't print my book. So these things are in tension because copyright is a special privilege that lawmakers create that basically infringes the property rights of others. That's one reason I don't think we should call copyright a property right, because it actually violates other people's property rights. Now, it may be a good idea to do that because it achieves some overarching public good. And I think you can make a strong case for copyright, that overall, by and large, it's a good idea. It is in the Constitution because it encourages the creation of new books and papers and works of music and paintings, and that's a wonderful thing. But there's a price to be paid. And part of the price that we all pay for copyright is that our property rights suffer infringement. So that's one way in which there's a tension between copyright and the rest of the Constitution, because the U.S. Constitution protects property rights very well. We have, for example, the Takings Clause of the Fifth Amendment. And the 14th Amendment also protects property rights. Copyright's in tension with that. Another way that copyright is in tension with the rest of the Constitution is that we have the First Amendment of the U.S. Constitution, which protects our freedoms of expression. And with copyright, you can step up to someone and tell them to stop talking, especially if they're repeating your speech. Now, the way courts have ironed out this tension is they've said there's a difference between an idea and its expression. And copyright only protects the expression of an idea. It doesn't protect the idea itself. So if someone comes up with a story, say Gone with the Wind, and they tell a long story about how in the Civil War era there were plantation owners who went off to the Civil War and they suffered heartbreak and tragedy, and this is the whole story of Gone with the Wind, you can't protect that idea. Anyone can tell that kind of story, but you can't use the same words. So that's what courts have said, but it doesn't work very well. Why? Well, for a couple of reasons. We've already seen this in the law. Suppose that you want to, as someone did want to, write a story that comments on Gone with the Wind by telling it from a slave's point of view. The original story, Gone with the Wind, has a very romantic view of what it's like to live in the Old South, and kind of ignores the fact that many of the people were slaves. It was a very ugly fact. So the original story didn't talk about that, and later someone wanted to write a story told from a slave's point of view. The same story, but from a different point of view. And, at first the copyright owner was able to stop them. And that was a tragic thing, because this new story had something to add. And here's another problem. Sometimes you need to have the original words to convey the message. And I'll give you an example. Martin Luther King gave a very famous speech called I Have a Dream. And it's been very important in American politics, the things that he said. And it wasn't so much the ideas, although they were very powerful ideas. It was the way he said them. And if you want to convey the same message that Martin Luther King was conveying, you really have to use his words. You have to say, I have a dream. You can't kind of use different words and have the same impact. You can't say, I possess a reverie. It's just not the same. And yet, his speech is protected by copyright. In fact, it is owned by a British publishing conglomerate, EMI. And if you want to repeat Martin Luther King's speech, you have to have permission from its copyright holder, which is a foreign corporation. Well, that's just kind of strange. And more importantly, it's contradictory to the First Amendment. I think copyright's a really interesting topic for a number of reasons. One reason is that we've seen it change over time so much. From the 1790 Copyright Act, which only lasted for 28 years, to today's Copyright Act, which lasts for hundreds of years sometimes. And so that's an interesting question, and why have things changed? Another reason it's interesting is it tells us a lot about the nature of property. I'm a theoretician of property, if you will. And I think it's very important that we not overuse the word property, because I'm a big fan of property rights. What I see happening with copyright is people are starting to use property in places where I don't think it fits very well. And that dilutes the power of the idea of property. So for example, we start calling copyright a type of property. Does that make sense? In some ways it does. But here's a problem. With regard to copyright, our property rights, our so-called property rights, are sort of weak because there's the fair use defense. So if I'm writing a review of a book, I can quote a long passage of the book as part of my review, and that's fine. That's fair use. But you can't do that with traditional property. I can't just walk across somebody's yard and say, oh, it's fair use, you can't stop me. No, they put up a fence and they say, you can't use my property. And so the thing that's interesting from a theoretical point of view is, and troubling from a theoretical point of view, is that with copyright we see the notion of property extended very far. I would say too far. And so I got very interested in copyright for both these historical reasons. There's a story to tell. Why did things change? Was it a good idea? And there's also a theoretical question. Is it really property? Is this the way we should use the word property? And I think it's not. I think it's an overextension of the word property. It takes a long time to explain why, but that's why I've written a book about it. And I think the reason we can explain the growth of copyright is basically because of what we call public choice pressures. Basically, lobbyists have gone to Congress and convinced them to throw more goodies their way, as lobbyists will, and the public at large has suffered. This happens in many areas of government, and copyright is one example of that.